Hello, my name is Janan. I'm one of the lawyers at eLaw Alliance, and today's video is going to cover the topic of child support. Please keep in mind that the information I'm providing in this video is very specific to Canadian law, and even more specifically to Alberta law. And if you are looking for tailored one-on-one legal advice, you're not going to find it in this video. Today's video is going to cover the topic of child support in a general sense. But if you do want one-on-one tailored legal advice, by all means, give me a call at the office and I'll be happy to book you a free consult or a paid consult. You can reach us at 780-665-4955. All right, so on to the topic of child support. I've made a video about this in the past, but I think it's time for a refresher and an update. So I'm going to speak to you in general terms about child support. And the first thing I'm going to talk about is how we classify child support. There are really three types of classification of child support. One type we refer to as Section 3 expenses, Section 7 expenses, and Section 9 or set-off child support. Now, Section 3 expenses are meant to cover the cost for things that are related to basic necessities like food, clothing, and shelter. Section 3 child support is normally paid by the parent who does not have primary care of the kids. So for situations where one parent has more than 40% or 50% time with the children, they will be receiving Section 3 child support from the payor. Now, Section 7 child support is different than Section 3 in that it is an expense that both parents contribute towards according to the proportionate income. And Section 7 child support covers non-essentials or things that aren't basic necessities, such as soccer fees, school fees, medical fees, daycare fees, things of that nature. So once again, Section 7 is a shared expense according to each parent's proportionate income, meaning if, for example, the father earns less than the mother, then he will pay less of the Section 7 expense than the mother would. If they are earning about the same, then they're probably going to split the Section 7 expense 50-50. Now, another type of expense we call set-off. So this is when shared parenting is in place. So if you've got a shared parenting schedule where one parent and the other parent, for example, have a rotating schedule of week on, week off with each parent, or if there's, both parents have almost shared parenting or more than 40% parenting time, that could lead to the child support calculation being impacted in the following way. In a shared parenting arrangement, it doesn't happen automatically, but in a lot of cases, what you do is you take what amount the mother would have to pay if she were paying full Section 3 expenses, and then you would take what the father has to pay if he was paying full Section 3 expenses, and whatever the difference is between those two numbers is what the higher earning parent pays for child support. So in a shared parenting arrangement, child support is normally still paid if one parent earns significantly more than the other. That higher earning parent won't have to pay the full amount, let's say, of Section 3, but they will be required to pay child support at a reduced rate to account for the fact that they are literally sharing the children on a rotating shared parenting schedule. Now, when it comes to determining income for the purposes of calculating Section 3 or Section 7 child support or even Section 9 child support, where you look to first, if the payor is an employee, is line 150 of his or her notice of assessment. If you are an employee, that number, line 150, represents your gross annual income for that year. That's the number that you plug into the online child support calculator to come up with what Section 3 amount that parent has to pay. Now, when it comes to set-off or Section 7, because that's a shared expense, that means that even the parent that doesn't pay Section 3 child support has to provide their financial disclosure so that they can figure out what portion they have to pay for a Section 7 or to figure out the calculation for set-off or shared parenting arrangements. So there is financial disclosure requirements when you are trying to figure out the proper quantum for child support calculations. At the very least, the parties need to be exchanging with each other normally the last 3 years worth of notices of assessment, T1s, last few months of pay slips as a starting point. If you happen to be self-employed and are the payor of child support, you're going to have to likely do more than just provide your notices of assessment. And the reason is because sometimes for self-employed people, line 150 doesn't adequately capture what their income is. Some business owners only pay themselves a modest amount, but their business is, let's say, healthier than the modest amount that they pay themselves. And in that case, there is an argument to be made that line 150 doesn't capture accurate income for self-employed people, and what it would require them to capture the accurate income is for that parent to provide business information. So accounting records and statements, any tax information related to business, and in some cases, even more detailed information like actual ledgers that the business has. So there's quite a bit more of a requirement for disclosure exchange, or a more fulsome disclosure exchange when you're self-employed. You have to provide more information than just your basic tax information that an employee would have to provide. So keep that in mind. It can be a very comprehensive task to figure out what a self-employed person's income actually is. And sometimes even accountants get involved to help figure out that number. Now, moving on to another topic for child support. Back to Section 7 expenses. Section 7 expenses are supposed to be reasonable. What that means is it has to be something that both parties can actually afford. So if there is a Section 7 expense, let's say your kids want to do horseback riding lessons, or something that might fall outside of the scope of their parents' budget, then there's an argument to be had that you don't have to pay for that type of Section 7 expense. It has to be something that the parents can actually afford. And if they can't afford it, then the argument is it's not reasonable and doesn't have to be paid. But if it is affordable, then the other argument is also true, which is then you do have to pay your proportionate share of Section 7 expenses. Normally, the requirement is that you show receipts or estimates for costs so that the other parent knows exactly how much they have to contribute towards that Section 7 expense. So providing them the receipt or confirmation of the cost is a must. Otherwise, there's no validation or verification, of what exactly that Section 7 expense might be. And keep this in mind. There is a program in Alberta called the Maintenance Enforcement Program, and they're designed to literally do one thing, which is enforce child support orders and agreements, so that if the payor stops paying according to the order or the agreement, then maintenance enforcement can step in and do a number of things, including take away that payor parent's or that delinquent parent's driver's license. They can confiscate passports, they can garnish wages, they can seize assets and seize bank accounts. So they can definitely take quite significant measures against a payor that isn't abiding by their court-ordered or agreed-upon child support. The other thing I wanted to touch on, and there are so many things that we can touch on when it comes to child support, but one thing I want to touch on before the close of this video is what to do in situations where child support is owed to adult children. You heard me right. Adult children. So there is a rule that in some cases a parent will have to pay child support past the age of 18 under specific circumstances that include if the child is still dependent on the parents and living at home and going to school, like post-secondary, as an example. That is an example where child support could be paid even past the age of 18. Opposite to that scenario, if you have a child who at the age of 18 moves out, has their own job, isn't going to school, then you can expect that child support will end at 18. So for the example where the adult child is still living at home and is in a post-secondary program, keep a couple of things in mind. Yes, you might have to continue to pay child support for that adult child, but there are a couple of things that come up to keep in mind. Number one, the older the child is, the greater the expectation that they will have to contribute to some of the cost of their own education and care. For example, when it comes to education, that child might be required to exhaust whether or not there are scholarships available to them, bursaries, before they ask mom and dad for money. They may even have to get a job in the summer to help cover some of the cost of their education. That is a legitimate expectation put on adult children who are still receiving child support. It might be reduced to account for the fact that the child has to contribute now that they're older to some of that cost. Another thing to keep in mind is the following. In some cases where you have an adult child that's going to school, still living at home, and thus owed child support, but they have no relationship with the payor parent, let's say for no good reason they don't want to talk to the payor parent, that in and of itself could lead to the termination of child support. Doesn't always happen, but there is some case law to support the argument that a child who refuses to speak to the parent that is funding their education, and they refuse to speak to that parent for no good reason, that child support might be terminated. For example, let's say we've got a situation where the children live with mom, they're going to school, and dad is the one paying child support, and they are now in their 20s. Let's say they're 20 years old. If that 20-year-old refuses to talk to dad, just has a problem with dad, but can't articulate a specific reason, like there's no abuse or anything of that nature, if it really is just they don't feel like talking to their parent and maybe they're being a brat about it, those are the scenarios that could lead to the payor coming to court and saying, I want my child support terminated because my child, who is now an adult, won't talk to me for no good reason, so why should I have to keep funding their education? I have seen some cases where judges agree that in that kind of scenario, child support should be terminated. So there are many different things I could talk to you about when it comes to child support. There are so many nuances. What I've given you in this video is some very general information about how child support works. I will continue to put content out, little tidbits in terms of how laws work, including related to parenting, spousal support, and division of property. I'll provide that as well. But for now, that's my little tidbit of information with regards to child support, and keep your eye out for some additional videos on other family law topics.